Well, first of all, thank you everyone for being here. Thank you, Elena. And thank you to my dear colleagues, to Barak, to Ron. Great pleasure to be able to address everybody here and those at home, of course. Today. Okay. Just want to point out, we're discussing the Haredi draft, and right now, as we speak, I ought to be elsewhere. There's right now a funeral taking place for a young boy, 20 years old, who was part of Netzach Yehuda, part of the Haredi battalion in Kfir, who was mortally wounded a few days ago and died today. May his memory be a blessing. And just goes to show how nuanced and complex the issue is. Now, I'd like to address the issue that I was asked to address, which is the place of the law in the issue of the Haredi draft. And I'd like to argue there's some place for the law. And I'd also like to argue that the dominance of the law, the dominance of Supreme Court intervention can also be deeply damaging. So I'll start with this. In my experience at Hebrew University included a wide array of new exposures. I wasn't used to the kind of dynamic and the kind of atmosphere and events that took place on university campus. And one of them was a conference with Knesset member Moshe Gafni. Never seen him before, literally. And he came to Hebrew U, and I was finally able to meet Moshe Gafni face to face. And Gafni spoke about the Supreme Court and its attitude towards the Haredim. And he said, his words, there's never been a single, not one, Supreme Court decision that has favored the Haredim. Not one decision. I'm not going to argue the point now. It's not an accurate statement, but it's certainly a perception which is commonly held among Haredi society and also outside of it. And why? Why is this the case? So there's a paper that became a book by somebody called a professor in Israel called Amichai Cohen. And he presents two different theories or understandings of why there are so many Supreme Court decisions that are perceived to be anti-Haredi. I could list you a whole bunch very quickly. It's not just about the draft. It's about kosher food, and it's about funding for schools, and it's about the authority of the rabbinic courts, and many other potential issues. And the question is why? And he says, well, I have two theories, okay? One theory, he says, is because of ideology. It's all about substance. It's about ideology. And he says, well, listen, we know that here in Israel, there's something of a public conflict in terms of ideologies between those who uphold the liberal values of individualism, of autonomy, and generally speaking, of liberal values, humanism, secular humanism, versus the Haredim, who uphold different types of values. Those values are more duty-oriented than freedom-oriented. They're more community-oriented, public-oriented than individual orientation. And they're more God-centered than secular humanism-centered. And there's a clash between them. And as Shuki Segev has said, the Supreme Court has kind of self-defined itself as a spiritual shepherd of Israeli society, where the place where ideological disputes are settled, and the court sides with the liberals. And that's the ideological understanding of why decisions are perceived to go against the Haredim. Of course, this is very damaging. It's damaging. The perception is very damaging. Number one, because I would say the most important thing is that it very much undermines trust in the Supreme Court. The Haredim, latest figures that I've seen, this is from 23. The level of trust in the Supreme Court stands at 6%. 6%. I was surprised. It's 6%. That's not good, right? The court needs to enjoy public trust. It's not good. But there's other issues also. There's the thorny issue of enforcing liberal standards on non-liberal minorities. It's a thorny issue. There's an issue of, as it were, allowing those who win in the court to be radicalized, because even if they play their hand too far, they can rely on the courts to back them up. So things will be okay. That's one interpretation, ideological. There's a second interpretation, which is institutional. And this speaks a little bit to my colleagues before. And this is based on public choice theory or interest group theory. And that says, well, the Supreme Court has a certain job or a role of correcting potential, quote unquote, market failures of Israel's democratic system, where a minority can have a lot of power, right? The Haredi, they're happy to do whatever everybody else wants on 95% of issues, but there's 5% of issues where they're very staunch in what they want. So the draft is an example. Funding for educational institutions is another example. Shabbat might be a third example. But there's very few, a small set of issues where the Haredim they're die-harders. Okay, this is what we want. Everything else, whatever you guys say. So it makes them into very convenient coalition partners. But it makes certain issues very entrenched, because the Haredim are die-harders on those issues. And that's a kind of market failure. Or is it, right? Is that just democracy? Or is that a kind of market failure of democracy? So says Cohen, well, what the court can do on this is at the very least to expose the procedure, to ensure that it's transparent. And I think that could be very much the case for the first decision that was made concerning the draft. This is the 1997 or 98 decision, Ressler, where the court didn't weigh in on whether it's good or bad, legitimate, illegitimate, legal, illegal, that Haredim should be exempt. What the court said was that it's not okay for this to be done under the shadows of the defense minister's annual exemption. The defense minister said, because then you can hide behind professional considerations. You can hide behind, well, it's the defense minister. This has to be enshrined in law as a matter of proper procedure. And that's thank you. I hand it back. And that, we could argue, is a matter of public procedure. It's a matter of interest groups. It's legit. However, in the later decisions of the Supreme Court, and I'm speaking about the 2012 decision, the 2017 decision, the 2006 decision, all of those decisions went in a different direction. They went strictly, not strictly, but they went ideological. I'll give you a quote. This is from the 2017 decision, and it echoed the 2012 decision, striking Israel's law. Israel managed to put together a law with great difficulty, and it was struck by the Supreme Court basically because of the lack of equality. And I quote here from Solberg, who was the only dissenter in the 2017 decision. And he says, as I read the opinions of my colleague, the president, and the additional comments made by my fellow justices, it seems clear that beneath the veneer of formal lacunae in the law and factual figures is a decision that's based on ideology and values. And Solberg, he says, I yearn, he says, for a healthy balance between the values, competing values of Torah study on the one hand and the joint sharing of the social burden. However, he says, this cannot begin and cannot end with the law. And I quote from Justice Elena Kagan, United States Supreme Court Justice, actually a very good friend of Scalia. And I think that even though she's an Obama appointment, but her words here very much reflect, or at the very least, could have been said by Scalia, and she says, the very worst moments for the court have been times when judges have essentially reflected one party's or one ideology's set of views in their legal decisions. They just can't and shouldn't happen. And she goes on, I'll for love of brevity, I'll skip. But I will say the following. I think that over here at stake is much more than the issue of trust in the court. At stake over here is the basic issue of what's this all about. And in this, I'll concur with a statement that was made by my friend Barak. Later I'll dissent, but at this stage I'll concur. And I'll say the following. The Supreme Court decisions that focus on equality make it sound like the question that we need to face, the big question of Haredi service in the IDF, is a question of equality. Will we comply with the equality value, which is an abstract, liberal leaning, and very binary value, equality? Will we comply with equality or not? But the true issue is entirely different, and it's the following. The question is, will Haredi society internalize its part in the incredible story of the Jewish return to its ancestral homeland and the shared responsibilities, both religious and civic, that emerge from this recognition? Will we see everyone else living here in Israel as brothers, as achim, and therefore live up to the scriptural demand of Ha'achechem yavo b'milchama? Will your brothers come forth to war? V'atem tishvu po? Will we think of that? Will we accept that as a moral claim? Will we make the necessary efforts to ensure that Haredim can serve in the IDF while maintaining their core values and way of life? And of course, will we have partners, right, the army, broader Israeli society, that will be ready for this participation, including a range of concessions that are not easy to make? And these questions, right, alongside the distinction between those who are fully immersed in Torah study and those who are not studying Torah, and there are thousands of Haredim who are not studying Torah, young Haredim too, those distinctions are not legal distinctions. They're social, they're communal, they're ideological, they depend on sweeping trends, they depend on brave leadership, they depend on profound processes that are ongoing. They're not matters that can be forged but by the strike of a judicial hammer. They're very different. And I'll end. I know Elena is staring. I'm going to end. There's an article that was penned on Tzarech Iyun by myself. I wrote it. But this was a response, okay? That was in the response part of the articles. And the responder is a woman. I don't know who she is. But she asked for this response to be aired. And I'd like to read part of it just to emphasize the points. She writes like this. She says, I'm an observant woman. My husband is in the reserves. He didn't have to enlist. His division was disbanded last year. He's 40. But on Simchat Torah, he realized there was no way he could continue life as normal, even as the Jewish people faced mortal danger. He fought to return to the army, and he's been for several months in reserve without coming home. She says, I believe there should be a percentage of Haredi Jews who continue to study Torah and not enlist, but only a certain percentage, those who are dying in the tents of Torah, those who are fully immersed. That's our division of Torah scholars. But everyone else, they should be enlisting in the army. We need you. Our soldiers are tired, worn out. We have a long way to go. My husband's battalion commander told his troops, we're fighting on 9 fronts simultaneously. If the lifestyle is not suitable, we'll find the solutions. Will you give up another mitzvah because it's hard to find a solution? And these words, she says, draw from the depth of my heart, and I pray that they'll also enter into your hearts. And I found the plea moving. It doesn't draw from elusive and absolute values of equality or any other. It respects Torah students. It's ready to exempt them from conscription. It doesn't ooze contempt. It's formulated with respect, with sympathy. It's not a matter of complex legal reasoning. These arguments are simple. They're too simple to need to go to the court for these arguments. They need to be discussed within Israeli society. They need to draw from within Haredi society. They shouldn't be coming from the outside. They shouldn't be coming from the court. We owe it to ourselves to bring up these arguments, to raise them, and to ensure that they're heard, not only in the Knesset, but in broader Israeli society. We owe it to ourselves to ensure that changes that are required happen, and they shouldn't be interacting with the potentially damaging discourse that comes from the Supreme Court. Thank you.